Today we are talking about issues that manufacturers, franchisors, and other product and service trademark licensors should consider under the Wisconsin Fair Dealership Law, also known as the WFDL, if they are doing business with distributors, resellers, or service providers located in Wisconsin. You can also check out our separate discussion on issues distributors, resellers, and licensees should consider in determining if they may have protection under the WFDL. The WFDL protects certain types of businesses doing business in Wisconsin from termination or non-renewal of the dealer's contractual rights to sell another company's products or services without good cause, and also protects against substantial changes in competitive circumstances of the dealership. The rights provided by the WFDL are in addition to rights under traditional contract and common law. And the statute expressly states that it is to be liberally construed to protect dealers against unfair treatment by grantors who, according to the statute, inherently have superior economic power and superior bargaining power in the negotiation of dealerships. The WFDL also entitles a dealer to recover its attorney's fees and expenses if the dealer can show that the grantor of the dealership violated the statute. And it also allows the dealer, if successful, to obtain injunctive relief to stop a prohibited termination or other act in violation of the WFDL. Many manufacturers and licensors do not realize that their relationships with distributors, resellers, and licensees may be subject to the WFDL, and as a result, unwittingly violate the statute by failing to give proper notice and opportunity to cure before taking action that might be damaging to the other party. Before taking any adverse action against a distributor, reseller, or service provider, you should determine if the business may be considered a dealer under the WFDL. And if so, take appropriate steps to give written notice and, if appropriate, an opportunity to cure any deficiencies before taking a proposed action. A dealership is an agreement, either expressed or implied, oral or written, by which a business, defined as a dealer, is granted the right to sell or distribute goods or services, or use a trade name, trademark, service mark, logo type, advertising, or other commercial symbol in which there is a community of interest in the business of offering, selling, or distributing goods or services. The dealership must be situated in Wisconsin to be protected by the WFDL. The business that grants the dealership is known as the grantor. The courts have identified a number of criteria for determining whether there is a sufficient community of interest to determine that a dealership exists under the WFDL. And over the years, a variety of businesses have been found to be dealerships protected by the statute, including fast food restaurants, equipment dealers, grocery retailers, service providers, and even Girl Scout troop councils. There are few, if any, clear-cut situations that determine that a trademark license or distribution relationship is or is not a dealership, so you should consult an attorney knowledgeable about the WFDL to assist you in determining if your circumstances might qualify as a dealership relationship under the statute. If your business relationship is found to be a dealership relationship, the statute generally requires, except in certain circumstances, that a grantor give a covered dealer at least 90 days written notice of a termination, cancellation, non-renewal, or substantial change in competitive circumstances, including all of the reasons for the proposed action. The WFDL also requires that the dealer be given at least 60 days in which to rectify any claimed deficiencies. Good cause includes failure by the dealer to comply with essential and reasonable requirements imposed by the grantor that are not discriminatory as compared to requirements imposed on similarly situated dealers, or bad faith by the dealer relating to the dealership. Given all these considerations, including the potential for a dealer to recover its attorney's fees if there is determined to be a violation of the WFDL, and to get injunctive relief and monetary damages, even for a violation of the notice and cure requirement, despite a grantor having good cause for the action at issue, it is important for product manufacturers and other trademark licensors to seek legal counsel from an attorney experienced with the WFDL when entering into business relationships with Wisconsin distributors, resellers, or service providers. You should also consult with such attorneys before taking or threatening to take adverse action against such businesses doing business in Wisconsin. If you'd like to learn more, please feel free to contact us anytime. The information available in this video is for information purposes only and not for the purpose of providing legal advice. In the event you are in need of legal advice, you should contact your attorney with respect to your particular issues or problem. Transmission or receipt of information on this video does not create an attorney-client relationship, and it is not intended to be advertising. Wisconsin dealer law does not desire to represent anyone viewing this video who is in a state where this video fails to comply with all laws and ethical rules of that state. None of the information or advice contained in this video is intended or written to be used relating to any federal tax issue and cannot be used by any person for the purpose of avoiding any federal tax penalties.